My background is I'm an attorney, and my name's Ann Murphy, and I work at the law school, and my areas that I teach in are tax, which I know that's what you were hoping for today. I know that. But today I'm going to talk about another area of expertise, which is evidence. So I formerly worked at the IRS as a trial attorney. I know. Somebody always says, did you have to? And I said, well, I volunteered because someone had to. So I said, all right, I'll do it. But it was a great job. And so I learned, obviously, the rules of evidence and have been more involved in it since time has gone on. So I really enjoy it. I have a personal reason to have written about Alzheimer's disease, and that is that my mother had it, and at the time I wrote my paper, she was suffering from the disease. She has since died, unfortunately, from the effects of the disease. And so I'm honoring her today because she died October 4th, so it's relatively recently. But it was, an interesting decline. It's something we have to deal with, and fortunately she was pretty comfortable at the end, and so the disease is very different for different people, and for her she went back to her childhood, which was just wonderful. And so she thought her parents were still there, and she didn't know who we were anymore at the end, but it was comforting to know that she went to a place of comfort for her, which was very, very nice. So what I did with looking at Alzheimer's is I thought about the rules of evidence which affect the federal courts, and I thought, how are we going to deal with this onslaught of cases, because it is just growing substantially, just amazingly. And the good news is we're living longer. The bad news is we're living longer. So the reason that a lot of people are becoming, are having symptoms of the disease are because of age. And so there is early onset, which is separate from what I'll talk about today. So I'm looking more at the age-related Alzheimer's. A lot of people ask, is Alzheimer's the same as dementia? It actually is not. Alzheimer's is a type of dementia, and so it's one of the different types of dementia, but a lot of people call it the same thing. And so to a certain extent, it doesn't really make any difference because the two are very matched. But Alzheimer's differs because it is physiological, not that dementia is not, but it's a specific type. So it's these tangles within your brain. And I just found out yesterday, there have been some studies where those tangles are starting much earlier than we ever thought. So I'm kind of wondering if there's tangles right now in my brain, which is a little scary because it is inheritable, unfortunately. And so they're looking, though, and getting very, very close to a drug that at least will stop the symptoms of the disease. So what I looked at is, how does this affect the rules of evidence? How does this affect courts? And how are they going to deal with this? And so I thought about three areas. And so one was the concept of capacity. So you must be capable of testifying in court, or else you're not allowed to testify. Now the bar on that one is very, very low. And so when the rules of evidence were actually put into effect, they actually wrote, we can't imagine anyone who would not be capable of testifying. And so in the old days, way long time ago, and we got our rules of evidence from England, but in the very old days, what they did is they said certain people couldn't testify, just across the board. And so it was rather interesting, because if you look at merry old England, anyone who had any information about the case was not allowed to testify. So you probably think, well, that would make for a really interesting trial, since no one would have any information about what happened. The only people who could testify are the knights or the royalty. And I don't know what they were testifying about, but that was the rule. So it was very bizarre. And then through time, when we came here and adopted those rules as our rules, and then we put them together in 1974 and wrote them down, but we always had them since England, we allowed many more people to testify, and actually thought, it might be a good idea to have someone in there who actually knows what happened. So if it's a contract dispute, Perhaps we should have someone who actually heard what happened. If it was an oral contract, good idea. And so that's what they did. And the only people who could not testify at that point were felons. And they said felons cannot be believed. You cannot have felons actually testify. Now we let everyone testify. Everyone, even felons. And the theory is let the jury decide whether to believe them. And so the question about whether someone with Alzheimer's is capable of testifying, would have the capacity to testify, is something that generally the judge will allow, and the jury will decide whether or not they are to be believed, not because they're liars, but perhaps their memory isn't so good. So there's a number of cases with memory that is not very good. And generally the court will say, do you understand today you are to tell the truth? And they'll say, yes, I understand that. Okay, you're good to go. And then sometimes they'll say the wrong name. Sometimes the witness will say the wrong weapon. And so there's a case where the witness says, well, they approached me, it was a purse snatching. They approached me with a gun. And of course the prosecutor's going, it was a knife. So are you certain it wasn't a knife? No, it was a gun. And you're going, oh shoot. And so the jury will look at that and say, well, we do believe your purse was stolen. We believe there was a weapon. And so it's okay that you now think it was a gun versus a knife back then. And so the jury can figure that out. And that's what we're gonna let the jury do. The judge, him or herself, will decide whether or not they can sit on the stand. So that is pretty easy. That is, now there are a couple cases where the judges said, oh, they have dementia? Well, they can't testify. But those are few and far between, and frankly, they're wrong. They're incorrect decisions if you look at the law. Okay, so the second area I went to is there's an area of hearsay. And hearsay is this whole giant awful area that my students can't stand, because there's 34 exceptions to hearsay. And they go, do we have to know every one? I'll say, yeah, every single one. And I hope you know it word for word. No, they don't. Some are used more than others. So there's this one category, you can only use those 5 exceptions if the witness is unavailable. And so what they mean by unavailable is the testimony is unavailable, not that the person is unavailable. So you've got the person on the stand. We've decided that they have the capacity to testify. Now we have to figure out whether they are unavailable for purpose of the rule. Now you might be thinking they're available because they're sitting there. Well, duh. And the rule is their testimony unavailable. So you're asking them questions about the transaction in issue and they have no recollection of it. That would be unavailable for purposes of that hearsay exception. And then what you can do is bring in an earlier statement they made, perhaps to the police, perhaps to a neighbor, when they were in, they had the memory to actually testify about it, but they don't now. And so they bring in that earlier statement. And so oddly enough, they're unavailable for purposes of that hearsay exception, but they're sitting there. So what do you have to prove? You basically prove that they have no memory of that situation. And so interestingly, if you're familiar with Alzheimer's, usually, and cases do differ, but generally what happens is the person loses the memory in the order that they acquired it in reverse. So what they lose is the more recent memories, and what they retain are the older memories. So it's fascinating because my mother would not remember something that happened the day before, but she could sing you the Janesville, Wisconsin fight song for her high school. I mean, word for word. She knew every bit of it. And she remembered her friends from the past. She knew who her buddies were in high school. She did not, at the end, know who her grandchildren were or her children, because that was more recent. And so that's how it's lost. And so what would happen is someone could testify perfectly about something that happened in the way past versus not remember at all something that happened yesterday. So what happens, unfortunately, is elderly people are the victims of crime very often because they can't walk as fast, they can't run after someone who just assaulted them or stole their purse. And so, but that is a recent event. And so they may not remember that portion of it. And so for that respect, they would be unavailable for purposes of the hearsay exception. So if they told the police officer right then, after it happened, and they recall, they say it was a person with a red shirt and a baseball cap, That earlier statement would be allowed in at trial because they would be considered unavailable now, so that hearsay statement would be let in, which is really interesting. Courts differ on how they're looking at this, but generally they'll treat someone as unavailable for purposes of the hearsay rule, but available for purposes of testifying, which is interesting. The area I was really interested in is an area that the Supreme Court has looked at a lot recently, which is the Confrontation Clause. So does anyone know what the Confrontation Clause is? I know, everyone's kind of like, I've heard it, it kind of, it's somewhere in the recesses of my mind. It's from the Sixth Amendment. And so it's a constitutional guarantee, and it's a clause, it's a part of the Sixth Amendment. So the Sixth Amendment also says speedy trial, jury trial. You have a right to a speedy trial, you have a right to a jury trial, and you have the right to confront a witness against you. And so the interesting thing is, if the person's there, yet they have no recollection of what happened, can you confront them? And so what is confrontation? And the Supreme Court in the past has defined it. So when I went to law school, which was many, many years ago, in the 80s, at that point it was defined as the same thing as hearsay. And so if it passed a hearsay exception, it was in for confrontation. That all changed with a Washington case, believe it or not, and the case is called Crawford versus Washington. And it blew the lid off this area, and it's been fascinating ever since. Not that it wasn't fascinating before, but it's really fascinating now. And so the Supreme Court, every term, has had a case on confrontation and has redefined it. And so that was the area I was really interested in, because I thought, if someone is on the stand and they're there, are you able to confront them if they have no recollection of the event? And so they were assaulted, someone stole their purse, or they were, someone hit them. They have no memory of that. Does the defendant have the right there? Would it count as the right to confront? So what I looked at, and this might surprise you, is a case which was decided prior to this blow open of the Confrontation Clause. It's a case called Owens. What happened in Owens is it was a prison guard, and he was hit with a lead pipe very hard on his head multiple times by an inmate. And he fell to the ground, there's blood everywhere. They take him to the hospital and they say, "What happened?" "I don't know." So a police officer comes about 10 days later and says, "What happened?" And the police officer takes a statement down, and the person said, "It was Bob, the inmate, who hit me. And I remember it. I went to the ground. He was behind me. He hit me with the pipe. I went to the ground. Blood all over the place. It was Bob." So the police officer writes, "It was Bob." And now you get to trial. And unfortunately, the brain was so damaged by this lead pipe that the prison guard has no recollection of anything. The assault, talking to the police, being in the hospital, nothing. But he's there. He's sitting on the stand. And so the question that the defendant raised was, I don't have the right to confront this person. You're bringing in this earlier statement, and I can't even cross-examine this person and say, well, how do you know I was behind you? How many people were behind you? He has no recollection of it. So if there were 10 people behind him, and maybe he thought it was me, at least I could ask him, how many people were behind you? Oh, 10? So how do you know it was my hand that hit you with the lead pipe? And he said, I can't confront this person. There's nothing I can ask, that's going to make any difference. And it was really interesting because it went to the Supreme Court, and it was decided by Justice Scalia. He wrote for the majority, and it was a fractured decision. So there were a lot of dissents to this. And basically what Justice Scalia said is, hey, he was there. And the defendant said, well, I know he was there, but it was like a mannequin. I mean, I can't question this person who has no recollection of the event, of the hospital stay, of talking to the cop, of anything. And what Justice Scalia said is, it says cross-examination. Were they there? Yes. Could you ask him questions? Yes. He said he didn't remember, right? Yes. You cross-examined him. Whoa. My students always think, really? Are you kidding? They call that confrontation? Yes, they do. At least they did. So the question now is, that was when you had a hearsay kind of mentality about the Confrontation Clause. Since then, things have changed dramatically. And so one of the things I looked at is, would the court decide differently today? So if you had someone with Alzheimer's on the stand who is there, who could actually answer questions, what is your name? I think it's Mary. Could it be Susan? Yeah, it could be Susan. Yeah, so you have someone you can ask them questions, cross-examined. It doesn't say it has to be good cross-examination, it just says it has to occur, it has to be there. But what happened since is the court used the terminology in this Crawford case, effective cross-examination. So has everything changed since this Owens case? And that's what I looked at in my paper, and I said, has it changed? And what's interesting is the Crawford case was written by Justice Scalia, of all people. And so he used the terminology effective cross-examination. So if you've got the person there and you're asking them questions and they say, I don't remember, I don't know where I am, and the judge says, will you tell the truth? Oh, sure, I'll tell the truth. Where are you today? I don't know, there's a desk here. What day is it? I'm not quite sure. What month is it? I don't know. Who are your children? I'm not quite sure. So you have some really big memory loss. Would that be enough for confrontation? And my theory is no. That things have changed since the Crawford case, that even Justice Scalia, who wrote Owens, would decide differently today. But what do we do if that's the case? Are we just going to throw out these assaults, these crimes against someone who actually has Alzheimer's because they're not capable of effective cross-examination? Now, the thing with Alzheimer's, is, as you may know, is it's progressive. And so you have very early stages of it where there's simply, and you might think, oh my gosh, I have it because I don't know where my keys are. Everyone doesn't remember where their keys are. But there's some significant details that may be lost. And the early thing is the bills stop being paid. Because the person doesn't recall that they actually have to pay rent and that kind of thing. So those are kind of early symptoms, and then later on it just progresses and they lose more and more, and it's a hippocampus disease, and so those tangles are in the hippocampus and they're just getting, unfortunately, greater and greater, and you're having more and more memory loss. So what I suggested as kind of a cure is to look at the particular person, see where they are, and the only problem is Alzheimer's is very different for different people, very different. And so it may work for one, it may not work for another. But there's this thing called deposition to perpetuate testimony. And so a deposition to perpetuate testimony works just like testimony at trial, but it was taken a long time ago. And so if you know what a deposition is, it's they ask you questions prior to the trial. It's a little different from trial, because you don't have as much fierce fighting over a lot of things. The judge isn't there either. And so it's written down, it's recorded, and both attorneys are there and they're asking questions, but you don't have a judge who's saying yes on this particular rule of evidence or no on that particular rule of evidence. But it works similarly. So ordinarily, courts say you can't use depositions to perpetuate testimony unless the person died. And so generally what you'll do as an attorney is if someone is very ill and you know they're not going to make it till trial, you'll do a deposition to perpetuate testimony and you'll save it. And that's what you're doing. You're perpetuating the testimony for later. And so I said, why don't you, because some of these cases take a whole long time, especially a civil case, will take years to actually get to trial. So freeze the testimony now when they do recall, and then you can use it later. So even if they're sitting there, you're able to use this. So that was one of my suggestions, because ordinarily the courts do not allow that. Only in very limited circumstances. And so what you have to show to the court is this person is going to die by the time of trial. So I said, why don't you open it up a little bit and say, based on the progression of the disease, this person could have no recollection by the date of trial, or very diminished recollection of this event. So let's do it now, and then we can use that later. And of course, the jury can believe or not believe based on the circumstances, and that's fine. So it's a very interesting area. And obviously it's going to just balloon. And so the statistics are, by the time of the age of 65, the incidence of it will double every year. And so as you get older, and they call it the old and the very old. And so the very old is considered 85 and older, which I kind of like, because I was feeling kind of old, and I'm going, thank goodness I'm not very old. Now, if you ask somebody who's 85, if they're very old, they're likely to say, no, I am not. Because old is always 5 years along the road. The old are the 90-year-olds. And so no matter who you ask, they're going to say it's older. But by the very old, 85, half of the people will actually have symptoms of Alzheimer's. It is huge. And at this point, there's no cure. There's not even a way to slow the progression. We were getting really close. 2 drug companies were very close. They were in the last stages of testing 2 different drugs, and in the last stage it failed. So they found that it indeed did not work, unfortunately. But there's a lot of money here. And so if you can figure out a drug that would slow the progression, and we hope someday to stop the disease, that would be terrific. And the drug companies are actually, of course, very interested in doing this, because it's a lot of money for them, because this is horrifying for families, for the person. You're taking away everything they ever knew, which is just an awful situation. And so it's tremendous. And we're hoping that there's going to be some progress in that area. And as I said yesterday, one of the things they're finding out is maybe those drugs didn't fail. Maybe we just didn't use them early enough. And so they find the tangles are starting a lot earlier than they thought. And so you're looking at somebody who may be 40 or 50, in 20 years, they're likely to have Alzheimer's. Could you start the drugs now? Slow down the progression, slow down that situation, and then hopefully later they will have less memory loss. The interesting thing is, who's going to volunteer to do that? Because you know most drugs have side effects. And you know what? I'm going to volunteer. Unless the side effects look pretty bad, I'm going to say, you know what? It's through the mother many times, and so it's my mother who had the disease, and so I'm signing up. Count me in. So that might be a stupid thing to do, but I'm there, Tell me what I can do, sign me up, I'm in line. So yes, and it could have very bad side effects. But to see what can happen and like I said, my mother had a fairly easy end because she was happy, which is tremendous, but that doesn't always happen with people. And so it really depends on the circumstances. So I was going to see if you had any questions.
Thank you.
You are welcome.
Do you have time for a question or two?
Yes.
Okay, on your point about confrontation, if the attorney is confronting the person with memory loss on the stand and they can't remember, but their previous testimony had been introduced, would there be the possibility that the jury watching this, seeing the person struggle, that would cast doubt on the earlier testimony that's been brought in? Because how would one prove that they were more competent when that was taken 6 months, a year, 2 years ago than they are now? That just witnessing that diminished capacity would cast doubt on that evidence.
Yes, and they've done some studies on, they were comparing jurors' reactions to older people, to younger people. Who do they believe and who do they not believe? What's really interesting is they don't believe elderly people in terms of memory. even someone who has no diminished capacity at all. They just, and it's really our society that looks down upon old people. And so if you're in a party and there's elderly people there, you're like, oh yeah, whatever. You know, and you go and talk to someone who's important, who's interesting. We have a tendency to throw our older people away, which I lived in China for a year, and it's completely different there. Everybody huddles around the older person and says, you've got something to tell us. So it's really interesting. Although what's interesting about the jurors is they believe the older person. They think the older person is trustworthy. So whatever they say, even though the jury's gone, maybe they didn't remember it right, they also think they're telling the truth. Versus if you take college students who they compared them to, they actually say, well, you remember, and we know you remember, but we don't believe you. So it's rather interesting how you have that difference, but you're absolutely right. That could very well be the case. And so maybe don't bring the witness in at all. But the defendant is going to say, well, where's the witness? And I get to confront them, and I at least get to ask them questions. Is there a way the prosecutor could say, oh, sorry, they're unavailable today, really wish we could help you out? Generally, you're supposed to have the victim of the crime there. That is the purpose of the Confrontation Clause.
If I could follow up,
Yep.
that bias be compounded by the fact that in most jurisdictions, people over the age of 70 are often excused from jury duty.
Yes.
So you don't have maybe a jury of your peers.
Yes, and yes, and what was interesting about this particular area, and I was out of my element to a certain extent because I was looking at a lot of psychological studies and how jurors perceive people. So that's very much the case, but it is interesting because a lot of times the prejudice against elders, the elderly hold it too, which is really sad. But that's our society, unfortunately. And so the elderly people will also think that the elderly person can't remember things, but also think they're telling the truth. So are the elderly people telling the truth? Probably no more, and they would actually, they did this study having them lie, having them tell an untruth. And the jury still believed them. The jury that they were, it wasn't a real jury, but it was a psychological study, and they were testing the jurors' reactions. And so they had a fake trial, and they said, did you believe so-and-so? Do you think they remembered correctly? That kind of thing. So, and unfortunately, the elderly people had the same viewpoint as the younger people. Yeah.
I have one question here in the center. Sir?
Yeah. So you mentioned that one possible solution to this would be deposing the people, and so in order to perpetuate the testimony. But my understanding is that depositions generally require an accuser and a defendant. In a case where a crime has for sure been committed, yet no one's yet been accused, or at least not formally accused, is there any sense that some parallel process might go on whereby a court might say appoint a devil's advocate to serve as the to make some sort of deposition-like process occur, or at that point is that just way out of bounds?
Yeah, it is. I mean, it would be a great idea because I've done depositions. They are not like a trial at all. They're much more informal. You have both sides there. So you have, I worked at the IRS, so we had the IRS, me, and then you had the Taxpayers Council. But we're shaking hands, and it should be, you know, you're hoping that you can fight in court and not, you know, fight with each other. Unfortunately, that doesn't always occur. But it's much more informal. You don't have a judge there. You make the objection. So you still make the objection for the record. But the witness has to answer, unless it's a privileged communication. So you say, I'm objecting for hearsay purposes. The witness still has to answer in a deposition, so it's different. And in court, they do not answer, because the judge is there and says, no, I'm not allowing this. You don't have a judge there. Now you can, if you're really having some infighting, you can call the judge and say, because sometimes I would have the witness just wouldn't answer. And I would say, you're actually under subpoena, you have to answer. I'm not gonna, jeez. Okay, let's get the judge on the line, you know, and the judge would be like, what now, you know, and but it is very different. And so could you have a situation that really mimics a trial just earlier? That would be ideal if we could do something like that. Because what you're trying to do is get that memory before it's gone. And if you can do that, then the defendant has the right to confront. It's not perfect, but you're hoping that it's at least better. Because otherwise, what is our alternative? It's basically a crime against someone who has Alzheimer's will go unanswered. And you won't be able to convict that person because that person's statements are not in at all. Now, you may have other witnesses. So someone sitting on a porch says, well, I saw that guy take that woman's purse. So you've got another witness who says, I saw it happen. But a lot of times, they attack the elderly person when they're alone, in the alley, walking down the street with their groceries. And so they're the only witness. And so it is problematic. Yeah?
Is the medical profession entering into this at all? I'm imagining, for example, bringing a doctor's note that says, I have Alzheimer's.
Yes, yes. And it's interesting because there's a lot of shame involved in this disease, and there shouldn't be at all. And so we were always very open. My mother was open about having the disease. She was devastated when she found out. But I do know other people who have died of the disease, and they say, whatever you do, don't put that anywhere in the obituary, because I don't want anyone to know. And the family members will say, well, don't say that Uncle Bob, and it's so crazy because it's a medical condition. It's not, you're not a bad person, you didn't ask for it, but it's kind of hidden. And so a lot of people don't want the doctor's notice and certainly wouldn't go to the doctor to get any sort of diagnosis. And the weird thing too about Alzheimer's is there is no definitive diagnosis of Alzheimer's until they die. And so my mother's body, we actually, and with her consent, when she was still deciding things, she wanted her body to go to research. And so we actually, her body went to Rush Memorial Hospital in Chicago. And they will do an autopsy of the brain, because that's the only way they can tell for sure the person had it. Because otherwise it could be any number, it could be a different type of dementia, it could be strokes, it could be a number of things. And so they give us the research, and they will continue to keep us in the link on the research, which is really tremendous. But that's the problem too, is the doctor can't really say. They can say you have symptoms that are like this, but they actually can't say that.